Assalamualaikum warahmatullahi wabarakatuh to Dr. Norizan. We are from Group 9. Would like to present you about the cases MINACHI anak perempuan THURAISAMY versus ZURIZH Insurance Malaysia Berhad. Before we start, let me introduce you my group members. First is Muhammad Fadil bin Saharuddin. Second, Nur Syahira binti Muhammad Azhar. Third, Nurul Hafizah binti Azman. Fourth is Nur Fazana binti Tajul Arifin. And lastly, Nurul Aini Akmal binti Hamdi. Assalamualaikum. My name is Nur Hafizah binti Azman. Matrix number 046105. Today I would like to present about the cases which is MINACHI anak perempuan THURAISAMY versus ZURIZH Insurance Malaysia Berhad. Okay, from this part of introduction, the life issue was that one of the cuma anak lelaki Anggam, to which is a deceased and employee of Perniagaan Katiravan. So the date of diseases was due to drowning and not any other causes. And defendant declared that the life of insurance policy as null and void on the ground that the owner of the policy or the insured failed to disclose material fact. Okay, so these cases are related to Insurance Act 1996, which is Section 147, Section 150, and also Insurance Act Section 151. Okay, that's all. Thank you.
Okay, Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Fadil bin Saharuddin. So I'm going to talk about the fact of the case, appeal of death insurance claim. Okay, in this case, Lakshmanan anak lelaki Anggamutu was passed away on 15 November 2013 due to drowning. Postmortem report was stated the cause of death was asphyxia secondary to drowning. At the time of death, the deceased worked as a labor with Perniagaan Katiravan. The plaintiff, which is his mother, MINACHI anak perempuan THURAISAMY, came to know from the private investigator who came to her house to investigate the death of her son that at the time of death the deceased was insured with the defendant, which is ZURIZH Insurance. The plaintiff has sued the defendant for rejecting the life insurance claims made by the plaintiff. The defendant had rejected the claim due to the deceased did not disclose the material facts during the application of the policy. From the history of the deceased was found that he had been imprisoned before in 2005 and 2011 due to drug-related offences, Section 12(a) and Section 15(1)(a) of the Dangerous Drug Act 1952. Thank you.
Based on the pleadings of the plaintiff and the defendant, the main issues which requires determination are as follows. First, whether the repudiation of the life insurance policy by the defendant is unlawful. Second, whether there was non-disclosure of material facts on the part of the deceased. Third, if the repudiation by the defendant is unlawful, whether the plaintiff is entitled to the insurance money under the life insurance policy and whether the life insurance policy is incontestable. Fourth, whether the provision in the supplementary contract P5, which limits the time for the death claim to be made within 2 years from the date of proof of loss being filed, is void for contravening the Contract Act 1950 and Limitation Act 1953. Finding of the court whether the repudiation of the life insurance policy by the defendant is unlawful. That's all from me for the issues of the case. So next we move to the next presenter.
Assalamualaikum. My name is Nur Syahira binti Muhammad Azhar. For my part is the decision outcome judgment. Okay, the first issue is whether the repudiation of the life insurance policy by the defendant is unlawful. There is no any credible evidence to support the plaintiff claim that the defendant and or his representative failed to allow the inquiry the disease or that the impression was obtained from the disease by deception or misrepresentation after considering the contemporary facts and oral testimony of the witness. The defendant has therefore discharged the burden of proving in application from D1 its defense on non-disclosure or incorrect disclosure. The defendant's denial of liability under the life insurance policy is lawful. Next, the second issue is whether there was non-disclosure of material facts on the part of the deceased. Okay, the defendant has relieved his responsibility to show that the details of the defendant were not revealed. If the death claim is made within 2 years of the date of implementation of the life insurance policy and as a result of such disclosure, there is a breach of the basic provision, then this court will not ask for the essential response provided by the death. Insurers are not obliged to demonstrate the cause and effect relationship between misconceptions and losses and are not obliged to demonstrate that misconception are factual problem of the insured risk, that is, that prudent insurers will be affected by such knowledge in making similar decisions. Next, we move to the third issue, which is there are two. First, the plaintiff is entitled to the insurance monies under the life insurance policy, as the repudiation of the insurance policy for non-disclosure of material fact is lawful. The above issues does not arise. Second, whether the life insurance policy is incontestable. Okay, the plaintiff argued that the life insurance policy had been in place for 2 years and could not be challenged, so the denial of the policy by the defendant was unlawful. If this policy remains in effect for a term of 2 years from the date of issue or the date of recovery, whichever is later, this policy shall not be questioned except for the payment of premiums or fraud. Last but not least, the issue is whether the provision in the supplementary contract P5, which limits the time for the death claim to be made within 2 years from the date of proof of loss being filed, is void for contravening the Contracts Act 1950 and Limitation Act 1953. So, the clause in supplementary contract P5 that restricts the time for a complainant to bring a case against the defendant is null and unenforceable.
In the case of MINACHI and ZURIZH, there are 4 sections involved according to Insurance Act 1996. First is Insurance Act 1996, Section 147 in bracket 4. In this section, it's stated on the period of life policy. In the case of MINACHI and ZURIZH, the defendant did not settle the claim as soon as possible, but rather to postpone it for almost 2 years, hence making the date to claim become expire. Secondly, Insurance Act 1996, Section 147 in bracket 5. In this case, the plaintiff's witness has come to conclude that the insurance agent at the time of the policy is being made has not explained in details of what the questions or statement in the form is. Number 3 is the Insurance Act 1996, Section 150. In this section, it stated about the duty of disclosure, which according to the case of MINACHI and ZURIZH, Lectumanan, the deceased, has not disclosed the fact that he has been on drugs for a few years before, which he did make a false statement by saying that he has never been on drugs before. And lastly, number 4, the Insurance Act 1996, Section 151. In this section, it stated about the knowledge of and the statement by insurance agent. The knowledge and statement that is received from insurance agent must be in the recognition of the licensed insurer, which means the knowledge that an insurance agent has is all from licensed insurer, and the knowledge that insurance agent has from a customer must all be informed to the licensed insurer.